Lawyers of Reddit. What's your best, most badass, I rest my case moment? Story 1. I'm relatively junior, so I'm hoping to top this one day. I defend professionals, and I brought a motion to dismiss a case on the grounds that the plaintiff could not prove my client was negligent, as she had not served the required expert evidence. As opposing counsel and I waited for our motion to be heard, we were sitting in the courtroom. The judge, who I did not know and who had not read our materials, wanted to talk to the parties of a short trial that was to be heard after our motion. That matter was also a professional negligence case, and the plaintiffs had no expert support. The judge then spent 10 minutes explaining that he had practiced in professional negligence for many years and was well versed in the evidentiary requirements to prove its elements. In fact, he said, I very rarely use the word impossible in this courtroom, but it is impossible for you to be successful without expert evidence. Our matter was then called, and I reveled in explaining to the judge that he was about to hear a motion to dismiss a professional negligence case on the basis that the plaintiff had no expert evidence. I won. Story 2. I mostly do solicitor work, so if I'm doing my job right, I don't get a whole lot of these types of moments. That being said, I had a longtime client who was being sued, and I got to shut down the guy suing him in a very satisfying way. My client had hired a guy, we'll call him Kevin, as essentially a right-hand man for his company. The employment contract wasn't finalized yet, but they had an agreement that Kevin would work 6 weeks at a lower wage, and then sign the contract and receive the agreed-upon salary. Kevin worked decently for 5 weeks and was then given the contract to sign. He came back to the owner, my client, and said he had some small changes he wanted to make. When the owner got the contract back, he discovered that the small changes included removing the duties and responsibilities section, basically the job description and the non-compete confidentiality clause. On top of that, Kevin had written in a higher salary than agreed upon and added a bunch of new benefits for himself. Obviously, my client told him he could either sign the contract as originally laid out or find another job. Kevin chose the latter. But then he filed a lawsuit against the owner, demanding to be paid for the 6 weeks he had already worked, which had already been paid, 2 weeks pay in lieu of notice, and 5 weeks of vacation pay. I had the enjoyable job of telling Kevin, in front of a judge, that he was not entitled to anything under the employment legislation, and the only way he could have received any of that would have been if he had actually signed the contract. The judge dismissed the case and awarded costs to the defendant, but not before giving Kevin a lecture on wasting the court's time. Story 3. I was in court trying to get more placement time with my 2 kids. My ex-wife and her sister were throwing every accusation imaginable at me. Abuse, stalking, rape, you name it. To give you an idea of the kind of nonsense they were pulling, they claimed I choked my daughter and then took her to the doctor in October 2016. According to them, the doctor even brought in a second doctor, and both supposedly said, we can't exactly call the police for this because it's unclear. I pulled the doctor's records later, and guess what? That appointment never even happened. There were several moments like this. For example, they claimed I angrily hauled my son out of their house because he wouldn't put on his shoes or coat in the winter. What actually happened was they had been arguing with a 4-year-old for 10 minutes about putting on shoes and a coat. They only managed to get his shoes on, so I picked him up and took him to the car. On the way, he stopped me and said he wanted to put on his coat, so we did. But this was supposed to be their big moment. He looked so angry and hauled son out of the house. My attorney had my ex's sister on the stand, and she was already shaky, muttering, dodging questions, trying to lie without outright lying. So my attorney asked, why did you think it was unnecessary for Bruce Lee 1255 to carry son out of the house? She said, because you can reason with son. He's 4. You really think you can reason with him? Yes. So in this case, did it work? She froze. Literally froze for about 5 seconds. It doesn't sound long, but in court, with everyone staring at you, it feels like an eternity. Finally, she said, well, it usually does. But in this case, did it work? Well, it usually does. My attorney just moved on. But the best moment, the one where I felt like I could have flown, came toward the end of the trial. My ex had spent 8 hours over several days trying to rip apart my character. According to her, I was violent, abusive, a rapist, and, oh yeah, one time I sent my daughter home with dog poop on her shoe. We called it murder, arson, and jaywalking. Like, if I'm supposedly so dangerous, why is dog poop even part of the argument? After all that, she still hadn't explained why she thought my daughter couldn't spend more time with me. She dropped hints, but never gave solid reasons in any communication. Even in her deposition, she never brought up abuse. Finally, on the last day, my attorney pinned her down. She said she was afraid my daughter wouldn't understand that mommy is going to come back. Basically, her big argument was that my daughter lacked object permanence. The judge asked her a few questions. So, are your son and daughter close? Oh yes, very close. Does daughter miss him when he goes to school? Oh yes, very much so. So, does she miss him because she loves him, or does she miss him because she thinks he's not coming back? Oh, she knows he's coming back. Okay, and just like that, in less than a minute, she torpedoed her entire argument. Her lawyer realized it immediately, but she didn't. They tried to scramble during closing arguments, but it was too late. The case was done, and I was granted more time with my kids. Story 4. Two high school kids spent the day antagonizing each other, so they decided to drive to a fast food restaurant to settle it with a fight. They parked, got out, walked straight toward each other, and swung. Kid A landed the first punch squarely across Kid B's face, instantly dropping him. The entire fight lasted just a few seconds and ended with one punch. The restaurant was then sued for failure to protect its patrons. The case was weak. Unfortunately, Kid B hit the pavement hard, suffered severe brain damage, and the plaintiffs were seeking millions. Attempts to settle went nowhere. We knew going in that they had two former employees lined up to testify about large crowds building up after school. The plaintiff's attorney wanted to argue that the restaurant should have reasonably expected trouble and should have had armed guards in the parking lot. Their witnesses, however, were disgruntled ex-employees who were fired, and their credibility was already shaky. At best, their testimony bordered on perjury. We also had a list of witnesses ready to refute their claims. At trial, the plaintiff's attorney went first. He spent a long time establishing the animosity between the kids, the severity of Kid B's injuries, and his lost earning potential. It was a lot of groundwork to build sympathy for his client. By day 2, after the lunch break, it was time for the defense to present. While discussing strategy, we realized the restaurant itself had barely been mentioned. The plaintiff was clearly holding back his star witnesses to rebut our defense that the restaurant was safe. So when we reconvened, defense rests, Your Honor. The plaintiff's attorney literally fell out of his chair. He scrambled frantically through his papers, stammering. The judge asked, I take it you'll need a few minutes for your closing? After the break, the plaintiff's attorney gave one of the weakest closing arguments I've ever heard. The jury's verdict: Kid B, 10% at fault. Kid A, 90% at fault. Restaurant, 0%. Story 5. So I called up my client's disgruntled former employee about a contract dispute he had started that dragged my client into litigation. After just 2 questions, it was obvious he was a lying son of a bitch. I didn't want to call him as a witness. He was too unpredictable. Instead, I just took down his story during our conversation. It was full of lies that could easily be disproven by documents, and it painted my client in a false and damaging light. I didn't let him know I had caught him lying. Fast forward a day. I submitted the required list of known witnesses to opposing counsel. Witness number 1, the lying sack of shit. Fast forward to trial. Opposing counsel calls him as their first witness, and sure enough, he acts exactly like the lying sack of shit he is. He repeated the same story he told me on the phone. I pulled out emails he had written, entered them into evidence, and proved he was lying outright. Turns out, my client hadn't breached the contract at all. The party suing had. After he left the witness stand, I asked the court for a brief recess, which was granted. I approached opposing counsel and reminded him that my client was still willing to accept the walkaway settlement. No money exchanged, no fault admitted. We had offered the deal 2 months earlier, and it had been angrily rejected. This time, they accepted immediately. Score. Story 6. I represented a man in a slip-and-fall case against a national chicken chain. The restaurant's policy was that grills weren't supposed to be cleaned until after closing because the process was a huge, sloppy mess. It involved applying chemicals, using a garden hose to wash away the grease, and could take 2 to 3 hours, along with packing up food, mopping, and scrubbing. Even though the corporation knew this, they only paid 1 hour of wages after closing. As a result, Shift managers and cooks started the closing process 2 hours early, while customers were still inside. This was dangerous because employees would track greasy water into the lobby. On one unfortunate day, 2 hours before closing, a cook was hosing down the grill. The slurry was so slick he had to wear a plastic smock and slip-resistant shoes. While waiting for the chemicals to work, he went into the lobby, tracking the grease into a hallway to wipe down tables. My client walked out of the restroom, slipped in the greasy water, and hit his head so hard it caused a subdural hematoma, requiring brain surgery. Conveniently, the video system wasn't working that day. Right after the incident, the cook was fired, and the corporation claimed they couldn't locate him during litigation. I tracked him down through a relative. He admitted he'd been cleaning the grill but denied tracking grease into the lobby, as did the other employees. Throughout the 3-week trial, the corporation insisted that cleaning before closing was against policy and that it never happens. According to them, something else must have caused my client's fall. Before trial, I asked the cook if they were still cleaning before closing. He was furious about being fired and told me, "Absolutely." So, on the first day of trial, I sent my investigator to the restaurant 2 hours before closing, the exact time of my client's fall, to record video on his phone. Sure enough, they had the hose out and were cleaning. I couldn't believe they'd keep doing this at the very location involved in the case. I sent the investigator back on a different day with a different manager and cook, and he caught them again. At the end of the trial, the defense put their regional general manager on the stand. He swore up and down that early cleaning never happened. He was their last witness. We asked for a sidebar in the judge's chambers and revealed the videos. The corporation's attorney freaked out. The judge allowed the videos in as rebuttal. The last thing the jury saw before deliberations was 5 minutes of video, complete with audio of the hose, showing employees cleaning the grills 2 hours before closing. In one move, we obliterated the defense's entire case after 3 weeks of trial. Needless to say, we prevailed. I should add, using sub-rosa video like this against a defendant is extremely rare. Usually, once a trial starts, they stop doing the bad behavior. I guess this restaurant didn't get the memo. Story 7. I argued a conversion case before a state court of appeals over a painting of a 1950s-era SEC coach that our clients commissioned and paid for, then loaned to the current coach. The new coach put it in storage, and another person found it. My friend won at trial and asked me to write and argue the appeal for him. It was my first appellate argument, so I worked my butt off. 3-ring binders with tabs I could flip to that matched my argument outline, practicing with friends, and barely sleeping the night before. I was pumped and prepared. The other side went first on appeal and got hammered by the court. Painful to watch and terrifying because I assumed I'd get the same treatment. When my turn came, I started my long-rehearsed presentation and was almost immediately interrupted with a question that went straight to my point, essentially making it for me. I agreed with the court and continued, only to be interrupted again with another on-point question. I answered, and before I could move on, a third question came, effectively closing my case for me. Realizing I could only hurt myself by continuing when the court was obviously inclined in our favor, I asked, "Can I answer any other questions for the court?" The bench said no, so I thanked them and sat down. I used about 3 of the 20 available minutes, and we won. Story 8. Several years ago, there was a big drug bust in my town where the cops arrested about a dozen people in a garage and charged them with manufacturing, delivery, possession with intent to deliver a controlled substance, conspiracy, and criminal organization, our version of RICO. I was appointed to represent one of the people found in the building when the task force raided the place. The police filed an 8-page affidavit of probable cause, most are 1 or 2 pages, detailing weeks of surveillance, the comings and goings of various participants, and their roles in the operation. I read all 8 pages and realized the only place my client's name appeared was on page 7, where it simply said, "The following individuals were present at the garage when the warrant was executed. Person 1, Person 2, Person 3. That was it. No mention of his involvement in the enterprise. Despite this, his bail was set at $250,000, ridiculously high, and the district attorney refused to agree to a reduction at the preliminary hearing. I filed a motion for bail reduction and came prepared to argue. When the case was called, I walked up ready to go, but before I could even open my mouth, the judge jumped right in. Normally, we present our arguments first, but this time the judge went straight to it. He said he had read the affidavit, acknowledged how serious the allegations were, and how much work went into the surveillance and raid. Then he looked at the DA and said, "But the defendant's name appears only once in the entire affidavit, and there's no mention of his involvement in the drug operation." The judge asked the DA, "Why shouldn't I grant defense's motion for bail reduction?" She stammered, We have evidence that this defendant was involved with picking up material from Philadelphia and transporting it here." The judge looked at her and asked, "Did I miss that in the affidavit?" She admitted no, it wasn't in there. They had just recently discovered it. The judge turned to me and asked if I had anything to add. I had come fully prepared to argue about the affidavit's deficiencies, my client's advanced age, his clean record for the past 20 years, and more. Instead, I kept a straight face and said, "I have nothing to add, Your Honor." Motion granted. Bail reduced. Story 9. A lawyer friend of mine handled this case. His client had moved into a newly built office building, and, while setting up their floor, they noticed a problem. There was about a 1-inch gap between the elevator threshold and the floor. It doesn't sound like much, but people kept tripping on it. Since construction was already underway, they hired someone else to do a small concrete pour to smooth it out. The original construction company found out, and, citing their still open contract, insisted on tearing up that fix and redoing it themselves. They did, and turned a minor nuisance into a disaster. Instead of fixing the gap, the entire elevator lobby floor was ruined. It was full of random dips and bumps up to half an inch, with no leveling whatsoever. When told this was unacceptable, the construction company doubled down. They sent the client a bill for the first redo, work the client hadn't even wanted, and added a quote for fixing the mess they'd just created. In court, the timeline was laid out clearly. Then came the kicker. An extremely precise, scientific presentation showing the floor's surface with high-resolution topographic maps that made just how atrocious the workmanship was undeniable. During cross, my friend leaned in while questioning the construction company's lead engineer and asked one devastating question. "Is this acceptable work for your company?" It was a perfect trap. If the engineer said yes, the client might technically owe for the redo, but the company's own lead engineer would be on public record admitting that shoddy work was acceptable for their firm. If he said no, then the company was stuck eating the cost of their redo, paying for the next fix, and going on record admitting they botched it. A true mic drop moment. Story 10. I wasn't a lawyer at the time. This was a high school mock trial, but it was still a blast. For anyone unfamiliar, mock trials are like real trials, but staged, with strict time limits so things don't drag on forever. Each side has about 10 minutes, maybe a little more if needed, to make their case. We were up against a local school in a case about an alleged hostile work environment. I was one of 3 attorneys on my team handling direct examinations, and my witness, playing the company's CEO, was a close friend of mine, so we were very well prepared. During trial, I got through my questions, passed across, and that's when the fun began. The opposing attorney got about 6 questions in before my friend gave an answer he clearly wasn't expecting. Instead of moving on or pivoting, opposing counsel just rephrased the same question over and over, trying desperately to get the answer he wanted. I could have objected right away with asked and answered, but I didn't. I sat back and let him burn through his time. For almost 10 minutes, he kept hammering at the same line, making zero progress. Finally, I objected. The judge, clearly fed up, said something along the lines of, "I would hope so." That's when I pounced. Instead of pushing the objection, I pointed out that opposing counsel had used up his entire time for cross and shouldn't be allowed to continue. So, after all that, he had only established my witness's name, age, workplace, job title, and that meetings happened there. None of it helped prove a hostile work environment. The judge kindly suggested he move on quickly, but it was too late. He was out of time. My own score wasn't amazing. After all, I missed an obvious objection for 10 minutes, but it was still higher than his, and we won. Another mock trial story. Me and a buddy were running late and ended up stealing a parking space on the way in. A minute later, the guy we cut off walked in. Turns out he was the judge presiding over our case. We lost that one. Officially, the judge said the other team got bonus points for a clever argument, but I'll go to my grave believing it was payback for that parking spot. So in one trial, I pulled a sneaky trick and walked away with the win. In another, I lost because of a parking dispute with the judge. Story 11. Not a lawyer, but I worked with our corporate lawyers on a patent infringement case. I was an engineer specializing in the technology at issue, a document scanning system. At the time, we had a partnership with a company that supplied OEM products for our lower-end scanners, while we were developing a higher-end machine of our own design. Just as our design was about to hit the market, they accused us of infringing one of their patents. The wording of their patent was extremely broad, and at first glance, it looked bad for us. They invited us to their HQ to discuss remedies, best case, licensing fees, worst case, scrapping our design. We met multiple times before the trip to prepare, and despite our engineering team's best efforts, we couldn't find a hole in the patent. We flew out to their HQ, had one last prep session in the hotel lobby, and braced ourselves for the worst. That's when I noticed something. The patent was very specific about how the scanning surface was held in place. It described a document surface resting on fixed rails, with the scanning head moving beneath it. But in our design, because we wanted to maintain a constant focal distance between the scanning head and the document, the scanning surface was actually supported by the head itself, not the rails. This allowed the surface to freely track any tiny up and down or twisting motions from rail deflection, dirt, or wear. In fact, if the head wasn't installed, the scanning surface would literally fall into the bottom of the unit. When I pointed this out, our lawyers looked at me in shock. We walked through it carefully, and then everyone started grinning. It was airtight. In the meeting, their lawyers, engineers, and managers laid out all their righteous outrage about our supposed infringement and the importance of finding a way forward. Then it was showtime. Our lawyer calmly said, "We don't believe that we violate your patent." I pulled out our prototype and demonstrated exactly how our design worked. The room went quiet. Their technical team asked me to show them again. Then they excused themselves for a private conference. We sat there trying to stay professional, but we knew we had them. When they came back, they were all apologies, talking about how much they valued our partnership and hoped it would continue as successfully as before. As soon as we left, we went straight to a bar and celebrated. By the end of the night, even our normally straight-laced corporate attorney was saying, "I love you guys, man." It was a great day. Story 12. I was helping a client fight for custody of his infant daughter. He was absolutely convinced that the child's mother was on drugs. His first attorney tried to explain that our state strongly favors 50-50 custody unless you can prove substance abuse by a high standard. But he insisted. He had found needles, a spoon, a band, and some substance wrapped in an old dish towel in one of her other kids' bedrooms. She gave him every excuse in the book. "Not mine, only tried once, I don't know how that got there." But he didn't believe her and kicked her out. He fired that attorney and hired me. I went straight into client control mode, setting expectations while doing everything possible to put safeguards in place to catch drug use. The problem was that we only had one incident, no current proof, and she was a very convincing liar, even by legal standards. Still, he pushed, so I filed to restrict her time, and we went to court. She testified well, told the judge she had only ever used once, and spun a story that he bought. I thought I'd done a decent cross, but we lost. The judge gave her essentially 50-50 time, ordered mediation, and set up regular drug screens. At mediation, we crafted a more detailed parenting plan that still gave her equal time, but included urine drug screens within 24 hours of a request, with conditions to prevent her from cheating. I warned my client, the only thing we could do was wait, monitor the screens, and be ready to pounce on the first slip-up. And slip-up she did, but always just enough to frustrate us. She was constantly late, sometimes by a couple of days. Her tests almost always landed on Wednesdays. We later learned a friend worked then. She wouldn't give me direct access to results, instead sending them to her lawyer, who faxed them to me. I pushed back hard, warning him each time that I'd file for contempt if he didn't fix it. My client was furious with each delay, but the standard was high, and we had to build a solid case before going back to court. Finally, after weeks of delays, missed tests, and a diluted sample, I filed for civil and criminal contempt. Another baby daddy was fighting a custody battle against her for the same reasons, so I coordinated with his attorney to share information. The night before our hearing, she took and passed a urine screen. I warned my client not to get his hopes up. We needed to think long-term. Court day comes. She's late. The judge starts without her, and her lawyer suddenly withdraws, citing lack of communication. She finally shows up as I'm presenting the timeline of her missed and late tests. She gives her usual innocent excuses, but this time the judge isn't buying it. He asks how she'd test that day. She swears she'd be clean. They screen her on the spot, and she fails, exactly as we expected. She tries scrambling, adjusting her story to fit the results, but the judge cuts her off. He flat out says he doesn't believe her. He strips her down to 4 hours of supervised visitation per week and orders her to pay child support until she completes an intensive outpatient treatment program. Only then would she have a shot at regaining custody. That little girl is now 5. The mom has never visited, never completed treatment, and never paid a dime of support. My client doesn't care about the money. He just wanted his daughter safe. It's a small town. He once saw her at a restaurant where she walked right by her daughter without acknowledging her. I've seen her out partying like she didn't have a care in the world. If you enjoyed the video, don't forget to leave a like and subscribe, activate the notification bell, and share a similar story or anything you'd like to say in the comments. See you next time.